Welcome to the last part of Law of Treaties. Coercion of a state, Article 52. A treaty is valid if its conclusion has been precluded by the threat or use of force in violation of the principle of international law, embodied in the Charter of United Nations. Article 52 clearly refers to Article 2.4 of the United Nations Charter, which prohibits the threat or use of force against territorial integrity or political independence of the state. In fisheries jurisdiction case UK versus Iceland 1973, Iceland argued that 1961 exchange of notes took place when the British Navy had been using the force to oppose the 12-mile fishery limit of Iceland and that they were void ab initio. The court rejected the argument because there was no concrete evidence for use of force. It stated that 1961 exchange of notes were freely negotiated by the interested parties on the basis of the perfect equality and freedom of decision on both the sides. Conflict with just cogence. Since states are sovereign, there is no sovereign political authority about the state. To enable interstate relations, state voluntarily surrenders to a certain portion of their sovereignty, and that is international law. Therefore, international law is consensual in nature. Its existence depends entirely on the consent of the state. Rules of international law are normally voluntary rules, just dispositivism. They can at any time be amended or abolished by the consent of the state by entering into new treaties. However, the new concept crystallized in the later 1960s, the concept of just cogence. Many states have come to accept that there are certain rules of general international law which are so important for the existence of international community that they are preemptory norms from which no derogation is permitted. They are called as just cogence, the compelling law, as opposed to just dispositivum, which is the voluntary law. States cannot contract out of them. Article 53. The treaty is void if at the time of its conclusion, if the conflict with the preemptory norm of the general international law. For the purpose of the present convention, the preemptory norm of the general international law is a norm accepted and recognized by the international community of states as a whole, as a norm form which no derogation is permitted, which can be modified only by the subsequent norm of general international law having the same character. A norm accepted and recognized by the international community as a whole. Chairman of the drafting committee's interpretation, all state less were very small numbers of states. The establishment of just cogence may not be affected if one state is isolated or refuses to accept the preemptory character of it, or if the state is supported by a very small number of states. Identifying the rules having the character of just cogence. Many rules have been suggested as candidates such as for just cogence. However, at present only a few pass this test. The ICJ in Nicaragua case quoted with the approval of the statement by the International Law Commission. The law of the Charter concerning the prohibition of the use of force in its constitutes a conspicuous example of rule having the character of just cogence. The least controversial norm having the character of just cogence are the prohibition of use of force, the prohibition of genocide, the prohibition of piracy of slave trading, the principle of self-determination, the principle of racial discrimination, the prohibition against torture, universally recognized principle of international humanitarian law. Consequences of invalidity. The main difference between the two groups of invalidity, the relative grounds, violation of internal law on the lawmaking, error, corruption, invalidation only on the concept of the state to be bound by the treaty. Absolute ground, coercion and just cogence invalidate the treaty itself and it renders it to be void ab initio. However, legal consequences depend on whether the treaty is bilateral or multilateral. In the case of bilateral treaty, the legal effect of the establishing a relative ground is the same as that of the establishing absolute invalidity as the treaty falls. In case of multilateral treaties, however, establishing an absolute ground means that the treaty is null and void without legal effect, whereas establishing a relative ground does not affect the validity of the treaty as a whole as between the other remaining parties. Termination and operation of treaties. Internal and external grounds of termination. Internal ground. The general rule in Article 54, the termination of the treaty or the withdrawal of the party may take place. There are two ways in which it takes place. First one, in conformity with the provisions of the treaty. Second one, at any time by the consent of all the parties after consultation with the other parties. In practice, the majority of modern treaties contain provisions for termination or withdrawal. Sometimes the treaty shall come to an end automatically after a certain time. Other treaties merely give each party an option to withdraw, usually after giving certain period of notion. There are three external grounds: material breach, Article 60, supervening impossibility of performance, Article 61, and fundamental change of circumstances, Article 62. Next, now we will see material breach, Article 60. The general rule is that the right to terminate does not arise unless the breach is a material which is a serious one. Article 60 subclass 3 defines a material breach as a repudiation of the treaty not sanctioned by the present convention. Second, the violation of the provision essential to the accomplishment of the object and purpose of the treaty. Breach of bilateral treaty. In a bilateral treaty, such a material breach enables the injured party to terminate or suspend the treaty at its discretion, Article 61. The injured party right to terminate or suspend a treaty is one of the main sanctions for the breach of treaty, but it is not the only one. There is nothing to prevent the injured state claiming compensation instead of or in addition to the exercise of its rights under the convention. Breach of multilateral treaty. The problem is more complicated if the treaty is multilateral. First one, it is obvious that breach by the state party cannot entitle the injured party to denounce the treaty because that would not be fair to other party, Article 62. Thereafter, a material breach of a multilateral treaty enables all the parties by unanimous decision to terminate the treaty altogether and to terminate it for the defaulting state only, Article 62. Likewise, a single state which is specially affected by the material breach may suspend the treaty between itself and the defaulting state. Next is the Nijmare project case. Gapichikova Nijmare project case, which was between Hungary and Slovakia in 1997. Hungary argued that it was entitled to terminate the relevant treaty because of prior breach of treaty by Czechoslovakia, for which action Slovakia was now responsible. The court held that it is only material breach of treaty itself, the state party to the treaty, which entitles the other party to rely on it on the ground of terminating the treaty. According to the facts, the court found out that Hungary could not rely on material breach of Czechoslovakia because Czechoslovakia alleged breach did not amount to breach but was a legitimate responsible, which a countermeasure to Hungary's earlier breaches. Next is supervening impossibility of performance, Article 61. Article 61 of the Vienna Convention limits the ground of the permanent disappearance or destruction of an object indispensable for the execution of the treaty. It cannot be invoked by the party that was itself instrumental in causing these circumstances to come out by the breach of its treaty obligation. Hungary and Czechoslovakia concluded a treaty in 1977 to facilitate the construction of dams on the river. Hungary later suspended works, arguing thus to establish a joint economic investment as required by the treaty was inconsistent with the environmental consideration. Czechoslovakia carried out certain unilateral measures in response to Hungary's failure to perform the treaty. Hungary then claimed the right of termination of the treaty on the basis that inter alia of the Article 61 impossibility of performance, stating that the essential object of the treaty was joint economic investment, which had ceased to exist. The court stated that since Hungary did not carry out most of the work for which it was responsible, the impossibility resulted from Hungary's own breach of an obligation flowing from the treaty. Referring Article 61(2) of the Vienna Convention, it was held that the termination was invalid. Fundamental changes of circumstances. Rebus 6 Stantibus, Article 62. It is better to be cautious in reference to this doctrine. Stability of the treaty relation is most important and a balance must be struck down. According to modern international law, the fundamental change of circumstances applies only in the most exceptional circumstances. Otherwise, it could be used as an excuse to evade all sorts of inconvenient treaty obligations. Article 62 of the Vienna Convention confines the rules within the very narrow limit. 61(1) says that a fundamental change of circumstances not foreseen by the parties, the existence of those circumstances must constitute an essential basis for the concern to be bound. The effect of change is radically to perform the extent of the obligation still to be performed under the treaty. Article 62(2) it may not be invoked in relation to the treaty established by a boundary. And second, Article 61, where the state may not invoke Article 62 if the change was caused by the breach of its own international obligation, either under the treaty in question or any other international agreement. Thank you for patiently listening to Law of Treaties.